That's right, this monitor's off. Good morning and welcome to the Public Service Commission. It is Friday, November 19th. This month is getting away from me. And we are here this morning for an allowable ex parte presentation. Let's take a roll call of commissioners. First, present in the hearing room is Commissioner Carol Lee Williams and Commissioner Belser. Present virtually, and that's a long way away for me to try to see. I see Commissioner Irvin and Commissioner Powers and Commissioner Thomas and Commissioner Caston. And do we have Chairman Williams on the phone?
Chairman Williams is here.
Thank you. Ms. Wessinger Hill, I recognize you to read the matter before us, please.
Thank you, Madam Chairman. Good morning, Commissioners, and to all who are present in person and virtually. Today, Friday, November 19th, we are here in the Commission's hearing room pursuant to a notice of request for an allowable ex parte briefing that was filed on behalf of Duke Energy Carolinas and Duke Energy Progress. The subject matter to be discussed at the briefing today is related to docket number 2021-349E, which is the joint petition of Duke Energy Carolinas and Duke Energy Progress to request the Commission hold a joint hearing with the North Carolina Utilities Commission to develop a carbon plan. This is a briefing and not a hearing. The briefing must be conducted in compliance with the provisions of South Carolina Code Section 58-3-260C. The requirements of that statute are in part that the allowable ex parte be confined to the subject matter which has been noticed. In this case, the issue noticed is the Duke Energy Carolinas and Duke Energy Progress request of joint proceeding as described in the petition filed in docket number 2021-349E. I therefore ask that the presenters, commissioners, and staff all please refrain from discussing any matters not related to this specific topic. Secondly, the statute prohibits any presenter, commissioner, or commission staff from requesting or giving any comment, predetermination, or prediction regarding any action by any commissioner as to any ultimate decision or otherwise on any issue which is either or is likely to come before the Commission. Third, I would ask that all presenters, commissioners, and staff further refrain from referencing any report, article, statute, or documents of any kind that are not included in today's presentation on behalf of Duke. A copy of any document that may be referenced during the briefing must be provided to ORS for inclusion in the record, which will be certified to the Chief Clerk of the Commission, Ms. Jocelyn Boyd. Finally, everyone in attendance, in person or virtually, must sign in or have registered. Everyone in the hearing room or watching live virtually must also read, sign, and return the form which you were given at the door when you came in today, or the form which we emailed to you for your virtual appearance. It is required by law for each attendee, whether attending virtually or in person, to certify that the requirements contained in South Carolina Code Section 58-3-260C have been complied with at this presentation. Thank you, Madam Chairman. The docket is in order.
Thank you, Ms. Wessinger Hill. Mr. Mustian from ORS.
Thank you, Madam Vice Chair. My name is Ben Mustian. I am the Deputy General Counsel for the Office of Regulatory Staff, and I'm here today as the designee for the Executive Director of ORS at this allowable ex parte. Many of my comments this morning will echo what Ms. Wessinger Hill just stated, but I believe it bears repeating many of the things that she has already identified. As the ORS representative, it is my duty to certify the record of this proceeding to the Chief Clerk of the PSC within 72 hours as to whether or not this briefing was conducted in compliance with the provisions of South Carolina Code Section 58-3-260C. The requirements of that statute are in part that the allowable ex parte be confined to the subject matter which has been noticed, which in this case, the issue noticed was the Duke Energy Carolinas and Duke Energy Progress request for a joint proceeding as described in the petition filed in docket number 2021-349-E. I therefore would ask that everyone here please refrain from discussing any matters not related to Duke Energy's request for a joint proceeding as described in the petition. Secondly, the statute prohibits any participants, commissioners, or commission staff from requesting, recommending, or giving any commitment, predetermination, or prediction regarding any action by any commissioner as to any ultimate or penultimate issue which either is or is likely to come before the commission. Third, I would ask that the participants, commissioners, and staff refrain from referencing any reports, articles, statutes, or documents of any kind that are not included in today's presentation to prevent the need for myself or Duke Energy's attorneys from having to track down copies or links to these documents to include in the record. Finally, as none of the information contained in the presentation appear to have been marked or requested to be granted confidentiality, I would ask that the presenters refrain from referencing or discussing any materials over which they would like to maintain confidentiality, and would ask that the commissioners please be understanding if the presenters decline to provide such information to the commission's questions here today. As a final note, please make sure to read, sign, and return the certified statement form, which I understand has been provided to all attendees. I also would ask that each person to please read the form carefully. This form needs to be signed by each attendee in order to certify that the requirements contained in South Carolina Code Section 58.3.260C have been complied with at the presentation today. Thank you, Madam Vice Chair.
Thank you, Mr. Mustian. Mr. Ellaby, we'll recognize you.
Thank you, Madam Chairman, and we first like to say how much we appreciate the Commission allowing us to make this briefing. We have, as reflected in the comments of Ms. Wessinger-Hill and Mr. Mustian, we have taken to heart the admonition that we not make any requests to this Commission for any commitment, prediction, or any suggestion of how anybody is going to rule on any of the matters that are covered by our petition. And we understand that rule. We understand that our asking for any prediction or commitment would be a violation of the law, and we also understand that the Commission any commissioner giving such a prediction or commitment would be a violation of the law. It's the last thing we want to do. We know there's been some concern expressed about this briefing, but we intend to make sure that do everything we can to make sure that there's no violation of those provisions. The point of the briefing is to give you the background of why we are asked for the joint proceeding and to talk about ideas we have on how we think it could work. With us, I'm going to turn it over to Mike Callahan shortly to make the bulk of our presentation, but just for the record, we have with us Marcus Preston. I was confusing you with a football player that I used to know for a while. Marcus Preston, who's Director of Regulatory Affairs, and Heather Shirley Smith, who's well known to the Commission in her former role as the Chief Regulatory Counsel to the company for South Carolina. And Heather has moved to a new role. She is Vice President, Regulatory Affairs and Policy for South Carolina, and she now is working closely with Mike Callahan. So with that introduction, I'll turn it over to Mr. Callahan.
Thank you, Frank, and thank you to the chair and the rest of the commission for your time here today.
Mr. Callahan, I'm sorry to interrupt, but would you pull that microphone a little bit closer to you? Sometimes we need you right into the microphone so that folks virtually can. That's much better. Thank you.
It's good to be with you here today. It's been a bit since I've been here. My last time with the COVID virtual hearing back in May of 2020. So let me jump right into my presentation. As you know, we've made an application with this commission and the North Carolina Utilities Commission for a joint proceeding to address important issues for our joint system. And where I thought I would start is with a bit of an overview of this joint system. I don't know if there you go. Perfect. Thank you. This doesn't appear to be working.
Little technical help. The clicker isn't working. Can we switch that from the back, or do we have another one? Or where do we need to point it? Let's put it that way.
I can also
Toward the
direct slide
screen.
changes if there's another way to do that.
Hang on, they're bringing another one, I think. Sorry about that.
I'm glad it wasn't just me.
Sorry for the technical difficulties, Madam Vice President.
That's all right. I like that. Do I get a raise? Please stand by. We're having a little bit of technical issue here for everybody virtually. We're at ease for just a second. There we go. Something moved. They're bringing you a clicker, Mr. Callahan.
Thank you. Thank you very much.
Where does he need to point that, please? Okay, thank you.
Perfect.
Thank you
So-
for your patience.
Absolutely. And as I mentioned, where I thought I would start is with a bit of an overview of our joint system. As you can see by this slide, when taking our Duke Energy Carolinas and Duke Energy Progress utilities together, our joint system serves 56,000 square miles across the Carolinas. This represents about 4 million customers in both states. Consistent with long-standing practice, the cost to serve those customers are shared between South Carolina and North Carolina, with our generation and transmission facilities allocated between our retail customers in both states, as well as our wholesale customers. As we noted in our petition, the Commission has recently approved an allocation of system costs for Duke Energy Carolinas, with approximately 68% to North Carolina retail, 24% to South Carolina retail, and 8% to wholesale customers. For Duke Energy Progress, those allocation of system costs are approximately 61% to North Carolina retail, 10% to South Carolina retail, and 29% to wholesale customers. For decades, that's how our system has grown, been operated, and been paid for. I think this is a critical point. The way our system has been designed has long reflected the fact that we operate as a joint system across South Carolina and North Carolina. In truth, our generation and transmission network would never have been designed this way, if not for the long-standing cooperation of both states to support this joint system. I thought I would give you some examples where I think this partnership has been notable. First, I think about our Robinson nuclear facility in Darlington County. Given the system cost allocations I just mentioned, with 10% of costs allocated to South Carolina retail customers, I think it is safe to say that Duke Energy Progress would never have built this nuclear facility in South Carolina had there not been assurance that both states would pay their share of the costs of that facility. I think about the engineering marvel in Oconee County, where you have a 3-unit nuclear site, the largest on our system, serving our Duke Energy Carolinas customers across both states. But it's not just a nuclear site in Oconee County. As you know, we were also able to couple this nuclear plant with our Bad Creek Pump Storage Hydro Facility, taking advantage of the geography in the upstate to build one of the largest storage facilities in the world, and with it, a treasure in Lake Jocassee. Again, had Duke Energy Carolinas been a standalone utility in South Carolina, it is doubtful that we could have undertaken a project of this magnitude. But with the support of both states, we made this a reality, and our customers in both states have benefited greatly from the carbon-free, affordable, and reliable power this system provides 24/7. Finally, I think about the number of coal plants we have located in North Carolina, given factors such as favorable access to railroads, and with it, access to low-cost coal supply. These plants have been instrumental in helping us keep our customer rates well below the national average. So again, I'd just like to really underscore that these utilities and their generation and transmission systems have been built, operated, and paid for collaboratively as a joint system operating across state lines for decades. I thought I would turn for a moment to Duke Energy in South Carolina. When I think about our roots as a company, what comes to mind for me is how 3 visionaries came together to harness the power of the Catawba River in the state. You may know that the first power plant of that young company was right here in South Carolina, up the road in York County. And 2 of those 3 visionaries were native South Carolinians, including Dr. Gil Wiley and William States Lee, a Citadel grad. And soon after, we began serving customers in mill villages and small farming towns across the state, providing power to the burgeoning economy of the region. Today, that means we serve around 800,000 customers across 30 counties in South Carolina. I can't talk about our operations in South Carolina without mentioning our proud nuclear history and some of the best-run plants in the world located right here in South Carolina. We operate 6 units at our Oconee, Robinson, and Catawba nuclear sites. To put this in perspective, that's over half of the 11 nuclear units we operate across the entire system in South Carolina and North Carolina. Again, I think this reflects the collaborative planning that has taken place across the Carolinas. Of course, with significant infrastructure like this, we have thousands of employees and retirees in the state. And we are a significant contributor to property tax base in South Carolina, with payments totaling $177 million annually. As we engage with our customers and other stakeholders, I'm reminded that all of this takes place in someone's backyard. That's true whether we are hardening the electric grid against extreme weather or cyber threats, exploring ways to grow renewable energy options for our customers, or simply volunteering at community events. We are proud to have helped grow the economy of South Carolina for over a century and have done so through significant business recruitment and retention efforts which have had a significant impact on this region and, in fact, across the state. The Palmetto State has been important to us, literally from the inception of the company, and remains so today. As I mentioned, we have a long history of business recruitment. The very nature of the reliable, affordable power we provide has helped attract major industry to our region. In 2020 alone, Duke Energy helped recruit more than $640 million in capital investment and more than 1,200 new jobs to the state. A humbling statistic for me is that the total economic impact of Duke Energy in South Carolina totals approximately $7.6 billion annually. And while South Carolina is increasingly an advanced manufacturing state with industries that need reliable power and competitive energy prices, one notable trend is that many, if not most of these companies, now have aggressive sustainability and carbon reduction goals of their own. Things are evolving at the fastest rate I've seen in my nearly 20 years at the company. This includes customers and industries demanding more from us when it comes to the energy mix they rely upon to power the hundreds of thousands of jobs they create. As you've heard from us before, Duke Energy is committed to a clean, reliable energy transition for the Carolinas, and this includes carbon reduction. This is what utilities generally mean when they refer to the energy transition. Transitioning to meaningful carbon reduction in the near term and achieving net zero carbon emissions by 2050. When you look at investor-owned utilities across the country, you will see the carbon reduction goals are not unique to Duke Energy. You'll see this across the sector with our neighboring utilities like Southern Company and our peers in the state like Dominion Energy. And you'll see it with other utilities such as Xcel Energy and AEP. As we think about this for the Carolinas, we've already retired approximately 6,000 megawatts of coal between 2011 and 2018. As you know, we no longer operate any coal units in South Carolina. And we are seeing more renewables with 4,200 megawatts of solar now on our system. These actions give us a great head start when we think about carbon reduction. In fact, we have already seen a reduction of over 40% in the Carolinas. As we continue to make this transition, we'll also continue to evaluate options that balance affordability and reliability. Options including solar, wind, storage, emerging technologies like advanced nuclear and hydrogen, to name a few. And something that is not on the slide, but as another alternative that we certainly seek to continue to grow, is energy efficiency as a portion of that mix. One thing I really want to emphasize is why the energy transition is so important to utilities like Duke Energy. And there are several macro factors at play here. First, we hear from our customers that they want to see us continue to take carbon out of our business. That's true whether you're talking about individual customers, and it's also true for many of the businesses we serve that have their own sustainability goals. Second, it's important to continue attracting funding at reasonable rates for our customers. As you know, we operate a very capital-intensive business to provide the service our customers expect of us. Whether connecting new customers, responding quickly to outages from storms, or maintaining our system to ensure it meets the reliability requirements our customers demand, all of this takes significant capital investment. It's now mainstream that investors choose where to invest their money with environmental, social, and governance, or ESG, issues top of mind. That's true whether you're talking about those who invest in our equity, or whether you're talking about debt investors who lend us money, and the rating agencies upon which many of these investors base their investment decisions. There are several other factors delineated on this slide that also contribute to the need to reduce carbon in the Carolinas. One more I'd like to mention is the importance of ensuring a resilient system that takes into account fuel security, including the continued reliability of coal for fuel supply. As you've heard in some of our fuel proceedings, the coal markets are distressed with increased volatility and uncertainty. Coal suppliers are reviewing their own business models as they consider ways to be less dependent on coal-related transportation. And their financial health has been weakened as they too face issues with access to investor financing as a result of ESG pressures. So as we think about the Carolinas, Factors like those I've mentioned will all be important as we consider our carbon reduction goals. I'm happy to report that the good news is we have a framework for the energy transition with the recent passage of House Bill 951, or HB 951, in North Carolina. HB 951 represents bipartisan policy to reduce carbon emissions, 70% by 2030 and net zero by 2050. Consistent with our own stated carbon goals and putting us on a path to cleaner energy while prioritizing affordable prices and reliable power. This legislation had overwhelmingly bipartisan support from a Republican-led legislature and a Democratic governor. Moreover, as you see on the bottom of this slide, these goals are generally consistent with what we put forth in our preferred scenario filed with this commission in our modified IRP. We believe those goals have been well received to date, with the preferred scenario in our modified IRP showing a path to achieve 66% carbon reduction by 2030. HB 951 is very close to that, with a target of 70% over a similar time frame. So I'll just highlight again that our goals at Duke Energy are consistent with what our customers expect, and that's to provide affordable, reliable, and increasingly clean energy to all Carolinians. Let me briefly talk about some of the key aspects of HB 951. HB 951 represents comprehensive energy legislation that addressed a number of policy issues that were being discussed in the state of North Carolina, several of which I'm not going to discuss today. Where I'd like to focus my time is on what's important to South Carolina, and that's really the light blue block that you see on the lower left-hand portion of this slide. This covers the development of a carbon plan to effectuate carbon reduction. As I mentioned, HB 951 represents bipartisan policy to reduce carbon emissions, 70% by 2030 and net zero by 2050. In developing a carbon plan to achieve these carbon reductions, the legislation was clear that regulators must do this in a least cost manner and use reliability requirements to protect customers. This balance will allow the Carolinas to maintain the competitive advantage that we've enjoyed as a region that maintains and remains a national leader in clean energy, with thousands of Carolinas' jobs and economic growth potential. Now that these carbon reduction goals have become law, the North Carolina Utilities Commission must undertake its review of a carbon plan, but it must do so while considering input from stakeholders. Let me stress that. The legislation mandates that the carbon plan is to be developed with stakeholder input. That's why we've asked the Public Service Commission of South Carolina to jointly hear the carbon plan, given that our generation serves both states. And while I don't know today exactly what that carbon plan will entail, I do know one of the biggest questions that utilities like Duke Energy will continue to face is how we replace our coal generation. This will require a diverse and balanced energy mix, including the evaluation of new and emerging technologies. And again, HB 951 makes clear that replacement generation of our coal plants must be least cost and owned and operated by the utility. HB 951 also allows for considerable new solar to be vetted through a regulatory process with a 55-45% ownership split. That means significant opportunities for solar developers in both states, with all solar continuing to be competitively procured. As I close, I want to underscore that what we are trying to accomplish is a joint proceeding that recognizes the importance of our joint system. As I mentioned in the beginning of my presentation, we have operated as a joint system for decades. And part of that has been the well-established practice of jointly planning our generation and transmission needs to ensure alignment to the benefit of our customers in both states. In addition to a joint proceeding, we want to recognize that carbon reduction is a reasonable planning assumption, whether it's codified in HB 951 or not. As a result, it makes sense that both states opine on a carbon plan. And I think it's important that we recognize that this plan does not exist today. We won't propose a plan until we have stakeholder engagement on what that plan should look like. Once proposed and filed, we want both commissions to hear from stakeholders who depend on our joint system in both states. We are asking for South Carolina to take a seat at the table, for our voice to be heard, to help determine the future for our operations in the Carolinas. We certainly hope others support our request asking this commission to use its authority under South Carolina law to seek to join the proceedings in North Carolina, with a deadline for the North Carolina Utilities Commission to rule on a carbon plan by the end of 2022. Time is of the essence. And I know my attorney has some specifics on how a joint proceeding could work, so let me turn it over to Mr. Ellerby to walk through some of the mechanics, and I'll try to advance the slide for you.
Thank you, Mr. Callahan. Mr. Ellaby?
Thank you, Madam Chair. This last slide, and I only have one slide, but it's rather dense. And these are proposals that we make to y'all for your consideration as you think about having a joint proceeding. The statute that we're asking the commission to exercise its authority under is 5827-170. It was passed in 1932. To our knowledge, it has never been used by the South Carolina Commission, but it clearly applies to a situation like the one that Mike just described for y'all. This is a situation where a joint hearing by the two regulatory commissions of matters that affect both states makes all the sense in the world and underscores the wisdom of our General Assembly almost 100 years ago in providing that could happen. So here's how we've given thought, and we've talked to people and heard issues or questions from various folks leading up to filing the petition. We think that, first of all, both commissions would maintain separate electronic dockets. All filings in the joint proceeding would be made in both electronic dockets. That would allow people who are used to the South Carolina system to see everything on the DMS. Same thing for North Carolina. We believe that, and of course Duke has does every day engage in producing materials and discovery in both states. The company believes that the discovery procedures are very similar in both states, that consolidating discovery and exchange of information will be a reasonable, seamless, more efficient for the parties, and will not cause any difficulties. We believe that and have agreed to or are ready to agree, if the joint proceeding goes forward, that ORS's audit rights under 58.455, which applies to the way that ORS gets material information from the companies, that would apply in the joint proceeding. The companies would agree to that, and that would allow ORS to use the tools that are at its disposal. The pre-filing of testimony, the two commissions for contested case hearings have similar approaches on pre-filing of testimony, so that would be something that would be, again, familiar to both commissions and could operate, we think, without much difficulty. We believe that once the two commissions decide, assuming that the two commissions decide to have a joint proceeding as we have proposed, and our petition describes the North Carolina provisions of law that we think apply here. But once both commissions make a decision, yes, we want to have a joint proceeding, we think that it is a reasonable interpretation of South Carolina's allowable ex parte, South Carolina's provisions on communications and restrictions on communications. A reasonable interpretation is that you've got a statute that allows for joint proceeding. You've got a statutory provision that allows commissioners to talk to each other. Yeah, there's a specific exemption in our statute that allows commissioners to consult with each other and with your staff. And we believe that it is a reasonable interpretation that if you have a joint proceeding, which is authorized under a different statute, the commissioners of the two commissions can consult with each other, consistent with the South Carolina restrictions on communications. We are planning on when we file our comments, we'll brief that and give you a legal argument, but we think that would be a reasonable interpretation, and we think that this commission, if this commission adopted that interpretation, any courts looking at it would give deference to the commission's interpretation. Our idea and our proposal is that the hearing, the testimony, the evidence being presented would be held before both commissions. Both commissions would be sitting. We do not know, we think y'all working with the North Carolina Commission and staff should determine how the logistics of that, whether it should be done in part virtually, whether you try to get both commissions together or some combination. But we think it can be done. The last 2 years have shown everybody that virtual hearings can be conducted. We've gotten better at it, as I'm told, and still maybe a few wrinkles to work out, but we think that can work. We think that helps a lot, and that had something to do with our thought that y'all would favorably entertain a request, is that you've now got experience with having a virtual hearing. We believe that because 951 requires the North Carolina Commission to adopt the carbon plan by December 22, we think that the chair of the North Carolina Commission should preside, would be our suggestion. They have a statutory mandate to take certain action in a certain time frame, similar to what y'all have had to do coming out of Act 62. So we think that it makes sense but somebody's got to chair the proceeding. Somebody has to be the chair. So we think for your consideration that probably should be the chair of the North Carolina Utility Commission. This is very important, and there's been some confusion about it as we've talked to folks. We do not think that in the joint proceeding, the two commissions will vote together on a joint order. Instead, our idea is that you have a joint proceeding, develop a joint record. The North Carolina Commission would meet its statutory obligation to approve the carbon plan by December 22nd. And then what we are, as described in our petition, what we're hoping this commission will do is follow that with briefing, South Carolina only briefing or comments, and then based on that record, would make a decision to, in effect, endorse the carbon plan by permitting, allowing, instructing the two Duke companies to use the carbon plan in our next IRP filings, which we are proposing be done in 2023, which is permissible, allowed under Act 60, under the provisions of Act 62. So that's really important. The commission will retain full authority to deal with what is before each commission. There won't be any en banc decision by a combination of the two commissions. And we absolutely believe that that what we're describing can be done without eroding the authority or the jurisdiction of either commission. As Mike described, these are the issues presented by the passage of Act 951 are really important to both states, really important to people in South Carolina. If we're going to keep the states aligned, as has been the case, we think that a joint proceeding is a great way to do that. Thank you for your attention, and we will be happy to answer any questions that y'all have.
Thank you, Mr. Allaby. Mr. Callahan, appreciate your presentations this morning. Commissioners, are there any questions for Mr. Callahan or Mr. Allaby? Well, hearing none, again, I thank you for coming quickly to describe this petition that was filed. And we appreciate your presence today. ORS, we appreciate y'all's attendance and your work to make this allowable ex parte presentation possible. And with that, we will close this allowable ex parte presentation. Thank you very much.
Thank you for your time.